the Bogosity podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity podcast for the week of November 24, 2024, the podcast that sits on a Ritz. This is your host, Shane Killian. Next week is Thanksgiving in the United States, so no podcast until December. Then there will be 2 more editions before the 2-week end-of-year break, coming back in the new year with the 2024 year in review. But before all that, let's mythicize the news of the bogus. The whole Alex Jones Infowars saga just got a lot more interesting. We covered the reprehensible ways in which basic defendants' rights were violated in his case, so we won't go over it again. Just suffice it to say, they got the whole Infowars brand and proceeded to auction it off. It quickly went all over the internet that The Onion had bought Infowars to turn it into a parody news outlet, lampooning the conspiracy cranks Infowars became famous for under Jones. Last week, Judge Christopher Lopez of the U.S. Bankruptcy Court for the Southern District of Texas halted the sale and ordered an evidentiary hearing, saying, quote, "No one should feel comfortable with the results of this auction. We're all going to an evidentiary hearing, and I'm going to figure out exactly what happened. I personally don't care who wins the auction. I care about process and transparency." And that's the weird thing. The auction wasn't transparent. In fact, the amount The Onion bid for Infowars wasn't even revealed until recently. Turns out, The Onion bid $1.75 million. That sounds like a lot until you learn that the only other bidder, First United American Companies, bid literally twice as much, $3.5 million. Christopher Murray, the trustee who oversaw the auction, told the court that The Onion bid may not have been as much cash-wise, but they were the superior offer. There's only one way to reasonably interpret any of this. First United would likely bring back Alex Jones and the rest of the personnel and let Infowars continue, whereas The Onion was going to turn it into a parody site. What's the part of this offer that makes it superior? It's what so many people said all along. This was not about righting wrongs made to the Sandy Hook plaintiffs, which was bogus for so many reasons we've already covered, but shutting up Alex Jones and taking his broadcasting company away from him. In other words, it was a blatant violation of Jones's First Amendment rights. Murray disgustingly tried to spin it by calling it, quote, "a disappointed bidder's improper attempt to influence an otherwise fair and open auction process," and that Jones, quote, "alleges, without evidence, collusion and bad faith in an attempt to mislead the court and disqualify its only competition in the auction." Civil penalties are monetary. That's how it works. The trustee should have been all about getting as much money as possible for the plaintiffs. This was not a disappointed bidder. This was a winning bidder that had their win taken away from them. And it meant less money for the Sandy Hook plaintiffs. By the way, this is exactly the way you shouldn't behave if you don't want to make Alex Jones even more believable when he calls this a deep state Gestapo conspiring to shut him down. To make matters even worse, the Texas Comptroller's Office requested copies of court records and notified the bankruptcy court that it intended to appear in the case. It's not an enviable position for Murray and the Sandy Hook plaintiffs, but then they did this to themselves. The only question now is not so much what the court is going to find, but how terrible is it?
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose Dapperton, Elon,
Not my Dogecoins.
Joe,
Build me back.
Shapiro,
My kippa's ruined.
or Don John.
Ow, my ear.
Forget those losers. You know you want to play as me, Lord Killian. That's right. You can stomp the skulls of those commie furries and save the universe as me.
7 complete different worlds with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
So let's at least look on the bright side. At least we aren't Europe. Sorry, European listeners, but I really feel bad for you guys sometimes. Like now, when I learned that the EU considers immoral patents to be perfectly fine. The whole idea of a patent is that you're claiming to have invented something. That doesn't work if the thing you're claiming to have invented already exists. The legal term for that is prior art. But the European Patent Office's Board of Appeal has said that this doesn't really matter so much. The plant extract Semalicalactone E is a chemical found in Quassia amara, a plant widely used in the Amazon to treat malaria. Its use as a malaria treatment has been widely known among Amazonians for centuries. Oddly enough, they didn't try to patent it. By the way, this isn't in dispute. The patent itself acknowledges its prior use, so it was opposed, claiming it contravened Article 53 of the European Patent Convention, which says, quote, European patents shall not be granted in respect of inventions the commercial exploitation of which would be contrary to ordre public or morality. Such exploitation shall not be deemed to be so contrary merely because it is prohibited by law or regulation in some or all of the contracting states. The opponent claimed that this was biopiracy against the indigenous people of French Guiana, including a direct deception and abuse of trust in their interactions with them, not informing them of the true nature of the research project, its objectives, the filing of the patent, and other risks to the community. That violated their IP protections of traditional knowledge. However, the Board of Appeal rejected that claim, saying, quote, the exclusion to patentability provided for in Article 53A requires the stated offense to morality to reside in the commercial exploitation of the claimed invention. The claims of the patent were directed to the formula of the antimalarial, a process of manufacturing the antimalarial, and its use in therapy. Given the dire need for effective antimalarial medication, the Board of Appeal found that the commercial exploitation of these inventions would not be contrary to public morality. On the contrary, they would be beneficial to society. Specifically, the Board of Appeal made a clear distinction between the morality of the commercial exploitation of an invention and the morality of how the invention itself occurred. In other words, we desperately need anti-malaria medicine, and it wouldn't happen at all without our wonderful patent system, so it's not an immoral patent. It doesn't matter at all if the invention itself is immoral, being based on prior art. European patent law, they say, doesn't care if you blatantly swiped the invention from someone else, as long as it's a use they need it for. And since they need it so desperately, it's better to have a single group have a monopoly over it so they can jack up the price as high as they can. Because if they rejected the patent, making the knowledge publicly usable, there'd be no generic producers at all making it or something. Of course, all patents are immoral, but really, all this does is prove that. If you can take something that's been used by people for centuries and patent it for that very same use, meaning government will give you a complete monopoly over it, what is that but immoral corporatism? Fortunately, in this case, there was enough of an outcry to make the patent holders not pursue it, but geez Louise. To all the people out there screeching that we should be more like Europe, just shut up. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. Okay, let's come back across the pond to get some good news, this time the Sixth Circuit denying a bogus traffic stop extension. The stop itself was fine, the driver in question being clocked as going 69 in a 55. We won't get into why speed limits are bogus, but that quickly turned into a pretextual stop that the officer had no explanation for. In 2015, the Supreme Court ruled in Rodriguez v. United States that traffic stops end when the objective of the stop has been completed. Once you give him the speeding ticket, you gotta let him go. This was a welcome pushback against pretextual stops, where a traffic ticket turns into a drug search and seizure of property or even arrest. The court said that, for example, you couldn't prolong a stop just to have a drug-sniffing dog do a search. In retaliation, despite the court specifying that there is no de minimis exception, cops have started to slow walk the traffic stops, asking drivers an unusual amount of questions, many of which are irrelevant and none of which you should answer without a lawyer. Or, officer safety is another good one to delay a stop. This is an absolute violation of Rodriguez. The point of the decision wasn't about whether or not you were completing the objectives of the stop. It was about whether you could extend the time of the stop without a good reason to do so. Kristen Cox, officer of the Knoxville Police Department's drug interdiction team, pulled over Nathaniel Taylor for speeding. She did the whole license, registration, and insurance thing, and he handed it over, but had trouble locating his proof of insurance. She told him that if he could find it, he could avoid a ticket. Then, when she went back to her patrol car to run his license, she found he had a criminal record. So she went about finding reasonable suspicion to extend the stop. Oh, and if you're wondering if she could have just looked up his insurance information, yes, she could have. Easily. The court said, quote, "Meanwhile, she also observed him making large reaching movements in his car, which she acknowledged were consistent with rummaging for the proof of insurance that she asked him to look for." Taylor eventually found documentation and flagged down Officer Cox by waving his hand and insurance paper out of the driver's side window. When Officer Cox returned to Taylor's vehicle, Taylor handed her an insurance bill, which Officer Cox accepted as sufficient documentation. Officer Cox informed him that she would not ticket him for driving without insurance. She also told Taylor not to make any further movements because he was making her nervous. But Officer Cox also acknowledged that the movements were because Taylor was doing what she asked. So, by doing exactly what she asked, indeed threatened to ticket him over if he didn't, he was making her nervous, and based on that alone, she called in a K-9 unit. So yeah, this escalated from a traffic stop from an officer on the drug interdiction team. Why are those team members doing routine stops? It sounds a bit like the idea is to specifically do these unconstitutional stops, doesn't it? The dog indicated the presence of drugs, but guess what? No drugs in the car. Amazing how often that happens. She did, however, find a firearm in the trunk, so she arrested him and he was indicted by a grand jury for being a felon in possession of a firearm. She also made bizarre claims, like the fact that he had air fresheners was suspicious because they could cover up the smell of drugs. She also said she didn't believe Taylor's stated travel plans, even though Taylor didn't give her his travel plans because she never asked where he was going. Quote, here, after learning that Taylor had just come from a job interview, Officer Cox didn't feel like he took the most efficient route to get to the address on his driver's license. But Officer Cox never asked Taylor where he was going. In fact, she admitted that she just made a guess about where Taylor was headed. Also, what does it matter if you don't take the most efficient route? They're all public roads that we get to drive on. What, it's wrong to take the scenic route now or something? Quote, because Officer Cox prompted Taylor's movements and Taylor complied with her requests, that factor holds very little weight. Similarly, Taylor's travel plans and air fresheners offer little, if anything, to the reasonable suspicion analysis. Adding his criminal history to the mix is insufficient to establish reasonable suspicion because it is combined with only these other weak indicators. Ultimately, this case lacks any of the stronger indicators of criminal conduct typically necessary to establish reasonable suspicion. The threshold for reasonable suspicion may be low, but it is not non-existent. Thus, we hold that Officer Cox lacked a reasonable, articulable suspicion of criminal activity that justified extending Taylor's stop to conduct a dog sniff. Oh, and by the way, there's no good faith exception either. Quote, the Supreme Court has endorsed the application of the good faith exception in 5 circumstances. None of these circumstances applies here, and we decline to extend the good faith exception to the exclusionary rule to salvage unconstitutional Terry stops. They reversed the lower court ruling and remanded the case, but since the evidence is now non-existent, there's no chance for a conviction here. It's good to see more appellate courts recognizing the dirty tricks cops play to deny our Fourth Amendment rights. Here's hoping the trend keeps up. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-aged children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins. And now it's time to nephrectomize this week's biggest Bogon emitter. And this week it goes to the United States Secret Service for claiming they don't need a warrant to track you on your phone. This was even controversial within the Secret Service, according to documents revealed through a Freedom of Information Act request. Their claim is that citizens, by installing ordinary apps on ordinary smartphones, agreed to be tracked by agreeing to the terms of service, even though none of those say the data may be submitted to authorities without a warrant. This is regarding a powerful surveillance system called Locate X, which allows law enforcement to very precisely follow a person's movements over a period of time. Last year, a Homeland Security Oversight report found that the Secret Service, along with ICE and CBP, broke the law by purchasing app location data from a wide range of apps using Locate X. According to the report, quote, U.S. Customs and Border Protection, U.S. Immigration and Customs Enforcement, and the United States Secret Service did not adhere to department privacy policies or develop sufficient policies before procuring and using commercial telemetry data, CTD. This occurred because the components did not have sufficient internal controls to ensure compliance with DHS privacy policies, and because the DHS Privacy Office did not follow or enforce its own privacy policies and guidance. The FOIA request revealed several internal emails within the Secret Service, one of which said, quote, if USSS is using Locate X, that is more concerning to us. LocateX uses ad ID from cell phones for location tracking. We previously raised concerns to OGC regarding the department's use of ad ID tracking as it relates to the Supreme Court case Carpenter v. U.S., which held that the collection of cell site location information constituted a search under the Fourth Amendment. The problem is, when it's used as an investigative tool, Carpenter can be hard to enforce. They can collect the data illegally, then use what's called parallel construction to work backwards, finding a seemingly legitimate way to get that information, like having an informant call in an anonymous tip and creating a narrative where they appear to have gotten the evidence legitimately. This can be very difficult to uncover in court. The LocateX terms of service say that the tool should only be used for internal research purposes and should not be used as evidence in a criminal case or in any legal proceedings. They knew about this back in 2020, as an internal email said, quote, "And speaking of terms of service, I wasn't aware of this. LocateX must be used for internal research purposes only, according to terms of use distributed to agencies, and law enforcement authorities are forbidden from using the technology as evidence or mentioning it at all in legal proceedings. That could conflict with discovery obligations in criminal proceedings." The emails also show communications with Babel Street, the company that makes LocateX. Quote, "I talked to Babel Street execs tonight, and their legal/privacy believes that Carpenter is not applicable. Users have to affirmatively agree for its collection and dissemination. It's not passively collected without user knowledge." And another email read, "FYI, a warrant isn't needed because the user gives consent. It happens when you agree to the terms of service." But that is not what Carpenter says. There's nothing in the TOSs that give any indication that the location data can be shared with law enforcement without a warrant. They also claimed, falsely, that the data is hashed and therefore cannot be tracked back to the end user, and so there's no problem with law enforcement using it. A demonstration of how LocateX works shows how it can be used to tell where someone lives or works, allowing their identities to be revealed to law enforcement. Even others in the Secret Service weren't convinced. One email read, "It seems questionable that the businesses who generate these location records would provide the location information directly to the government without a warrant, but they sell it to Babel Street, who then sells it to us." Senator Ron Wyden said, quote, "I've long argued that the Trump administration memo blessing the government's warrantless purchase of Americans' location data wasn't worth the paper it was printed on and would never withstand real legal scrutiny. It's not surprising to learn that even Secret Service officials raised concerns that this practice likely violated the Fourth Amendment. The Secret Service reportedly hid behind a flimsy claim that users consented to the sale of their location data, but even back in 2022, the agency told my office it hadn't bothered to actually verify this." Of course, the email that was the most damning was one from August of 2020 that read, "I think we should stay quiet on it." So all of that makes the Secret Service this week's biggest Bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now let's uninucleify this week's Idiot Extraordinaire. We've seen an immense amount of food recalls this year. And it's interesting because when you look at the Agricultural Adjustment Act and other such regulations, the whole idea was you can't trust those local farmers. They might sell tainted food. So now you have Big Agra in bed with the USDA and FDA, and guess what? They're selling tainted food. But a lot of this might be overstated because politicians are idiots who don't know what they're talking about. This is what we see with the Costco butter recall. The product recalled is Kirkland's Signature Unsalted Sweet Cream Butter for a missing allergen label, which, according to Forbes, is, quote, a slip that could pose serious risks for certain consumers. And why? Check out the FDA's official reason for the recall. Quote, butter lists cream, but may be missing the contains milk statement. Yes, the reason they recalled all of this butter is because the boxes didn't proclaim the fact that butter contains milk. Like we're dumb enough not to know that? And they give the consumer instructions, quote, for individuals with milk allergies, do not consume the recalled butter. Return it to your local Costco for a full refund. For individuals without milk allergies, the butter is safe to consume. However, if you prefer not to use it, you may return it for a refund. Wow, so you can still return it even if the butter is completely safe? How much is this going to end up costing Costco? And if you have a milk allergy or are lactose intolerant or whatever, do you really need the label to specifically say it contains milk? Isn't that something you'd already know? And yet, Forbes ecstatically passes on the fear-mongering by reporting, quote, beyond the immediate risk, this recall underscores the importance of accurate food labeling and the impact it has on consumer trust and safety. But what impact on consumer trust and safety do you think it has when you issue one bullshit recall after another and so trivialize the notion of a recall in the minds of the consumers? What happens then when you have a serious recall? And they go so far as to say, quote, the FDA's alert includes detailed product codes for consumers to verify, making it essential to double-check before using any Kirkland butter from recent Costco buys. Or you could just, look on the box where it says cream. You don't even need to look at the ingredients. It's called Kirkland Signature Unsalted Sweet Cream Butter. As if the word butter wasn't enough of a hint. What else do you need to double-check? It's like when you buy raw peanuts and you see on the package, ingredients, peanuts. Warning, contains peanuts. Yeah, thanks. We couldn't have worked that out otherwise. Not like the big word peanuts on the front was any big clue either. Forbes goes on about how vital accurate food labels are and how labels build consumer trust. If they're so necessary, wouldn't consumers demand them on their own? Why do we need mommy government to insist that they tell us that milk products contain milk? I mean, just listen to this, quote, errors like Costco's recent butter recall can shake that trust and leave consumers uneasy. This recall reminds us why labeling standards are more than just rules. They're a crucial part of protecting public health and consumer confidence. Seriously, if I didn't know better, I'd say this was the Babylon Bee. Statists are rapidly becoming parodies of themselves, like the Tesla recall we covered where, apparently, drivers were too stupid to recognize the internationally standardized symbol for park and instead required them to replace it with the word park that was 3% bigger. Why do I have a feeling that this is just an indication of what it will be like with RFK Jr. in charge of it? So all of that makes the FDA and Forbes as well this week's Idiot Extraordinaire. Well, that wraps up this. I rather like the idea of being an outlaw legend. I'm sure a few grand tales about me wouldn't do any harm edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Remember, next week is Thanksgiving, so no podcast. If you're in the U.S., stuff yourself with turkey. If you're not, stuff yourself with turkey anyway. It's good. We'll be back in 2 weeks. Until then, here's a quote from Robert Anton Wilson. Intelligence is the capacity to receive, decode, and transmit information efficiently. Stupidity is blockage of this process at any point. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.